Good afternoon to all of you here from London. Thank you all for joining today's event. It's great to see so many of you in attendance, and I can see that attendance is further ticking up now, for an insightful and practical look into one of the more pressing issues for General Counsel and indeed lawyers in general in China and indeed worldwide. My name is Jamie Riot. I am the Head of Research for the Legal 500 GC Powerless series, meaning I have the great pleasure to talk to in-house counsel all over the world, as well as recognize their achievements. We've been in China specifically since 2017, I'm very proud to say. And first things first, with today's webinar, let me please thank our partners, Links Law offices, without whom today's session would not be possible. I would also like to thank our speakers for joining us. I will give you all a proper introduction shortly, but just before I do that, let me outline the content that we've got in store during today's session. Now, I don't think anyone in the audience will need to be convinced about the potential seriousness of a cyber attack. A phone call in the early hours telling you a data breach has occurred, or news that your company's systems have been compromised by a denial of service attack are just two of the nightmare scenarios for GCs and compliance officers everywhere. The dramatic recent increase in remote working practices have increased security risks further, with employees taking home and exchanging sensitive company information over less than secure connections in many cases. This is a reality, and this is something that many will be dealing with, and the stakes are high. This means that today's topic is one of important and extreme urgency. This webinar, therefore, is designed to provide GCs with the essential knowledge on the practical steps that can be taken to mitigate, overcome, and manage cybersecurity incidents. Our speakers will impart lessons, share best practices and insights about the challenging and thought-provoking field of cybersecurity compliance, covering three main points in doing so. These are the responsibilities and obligations for companies under China's cybersecurity laws, the main legal issues in digital translation, as well as compliance of cybersecurity products and services. Now, if there's one thing that our audience should take from my short speech here, it's that these sessions work best when we have input from you, our audience. I therefore encourage you to submit your questions via the Q&A tab, so our speakers can address anything relevant that you would like them to over the course of our 60 to 90-minute session today. Now, without further ado, please allow me to introduce our distinguished panelists on today's webinar. First, we have Dr. David Pan, partner from Links Law offices. Dr. Pan is head of the firm's corporate compliance practice and comes as highly recommended in the field of cybersecurity. Second, we have Shun Yang, also a partner at Links Law offices. Mr. Yang is a partner in Links corporate compliance practice group also, and has been recommended by Legal 500 as a leading lawyer in the TMT field. Finally, we have Nigel Zhu, a senior associate at Links Law offices. Mr. Zhu is also a member of the firm's corporate compliance practice and has over 7 years of experience in the field of cybersecurity law, antitrust, and competition. Moderating today's session will be Dr. David Pan, and I will now hand over to David, who will begin this webinar proper. David, it's great to have you, and the floor is yours.
Thank you, Jamie. Thank you for your kind introduction. Hello, Jamie. Can you see the presentations?
I can, yep.
Oh, great, great. Yeah, dear all participants, thank you very much for your time to join our webinar. In this 1 hour and a half, together with my partners, my team members, and we will introduce you some basic concepts of China cybersecurity law and also some latest trend of legislation and law enforcement. I will give a start, and I will talk about generally the company's responsibilities and obligations under China's cybersecurity law, in short, CSL. So I will first I don't want to spend much more time to introduce myself. As Jamie mentioned, that I practice law in a lot of areas, and cybersecurity and data law is one of my primary focuses. And okay, I will just jump to my presentation. So when we're talking about, when you trying to figure out what kind of obligations your company, either like operating in China or has some connections in China, needs to do to comply with the CSL, cybersecurity law, you must first figure out whether your company is a network operator only, or is a CIO, critical information infrastructure operator. That's the first part we will touch upon. And the second, once you identify your company, like either being an ordinary network operator or like CIO, and then your company needs to consider whether your company has done or are going to complete the multi-level protection scheme, MLPS. And the second part, the major obligations, either like network for being a network operator or like being a CIO, needs to do the data classification and also the data management work. So I will start with the identification of your company status. Under China Cybersecurity Law, CSL, there's a definition of network operator. So a network operator means owner, either owner or administrator or user of the network. And this network is very broadly defined. It basically includes like any system which consists of like computers or other like information terminals. For example, your iPads, your other electronic devices. And that these computers and or other terminals, this equipment can collect, store, or transmit, exchange, or process information. And this system constitutes a so-called network. And then the owner, administrator, or user of such network is defined as network operator under the CSL. So as you can see, by this standard, almost every business entity, whatever your size, business size, if you have like more than 2 computers or 2 like terminals that process information, sending emails, placing orders, and this business entity will be identified as network operator. As a relief, when this like CSL is promulgated, there is kind of a confusion. For example, some home use, for if you have several kids, playing video games, they connect to each other, set up a small like network at your home, and this like individual whole household use network is not covered by the CSL. So, and then we need to, that's the definition of a network operator. And then we need to find out whether your company constitutes of the so-called critical information infrastructure operator. As the name tells itself, CIO basically means any like operator of like critical information infrastructure. And so it's actually kind of nebulous to determine whether an entity is a CIO or not. And then we'll give you some kind of methods to make a self assessment. First, CIO is determined by the authority in charge, some government departments, mainly the like industrial supervising authority. If there's no such industry, specific industrial supervising authority, and then the China Cyberspace Affairs Commission, in short, CAC, will be responsible for making the determination. Just give you an example of this like industrial supervising authority. For example, if any company engages in business like hazardous waste treatment, and then the PRC, Ministry of Ecology and Environment, will be the right authority to determine whether this hazardous waste treatment business undertaker is the CIO. So what does it mean if a company constitutes like CIO, and how to identify the CIO? We need to like spend like at least 2 hours, 3 hours to give you a detailed explanation, step by step, how to identify CIO. But constrained by time, I'll just give you like a very very high level summary. Basically, first we need to determine whether your company falls within the so-called critical industries, and then we will take a consequence test. Critical industries like include a couple of like so-called specified industries. For example, telecommunication, energy, transportation, finance, public utility, etc. Um, Having said that, it does not mean that any company, any business operator which engages business in these like sectors will necessarily be CIO. And the other way around, any company who falls out of the side of the scope, the business sector mentioned, it does not mean that this entity will definitely not constitute like the so-called CIO. It still will like, needs to go through the consequence test. It basically means that if any like, cyber incident, like hacking incident, or any like, network breakdown happens to this network operator, what kind of consequences? Whether it will bring like national security or national economic stability, or will affect like significantly people's livelihood. And then if the consequence is serious, and then this entity will be likely constitute the CIO. And then I will give you like a much easier like approach to make a determination. If your company like is identified MLPS like the third grade or even above, and then your company will be likely to be identified as a CIO. Okay, so thus we're talking about we have go through this like who are covered by CSL. In short, network operator. And there is like one special group of network operator, critical information infrastructure operator, CIOs. And the CIOs will bear some special or additional like legal obligations under the CSL. And we'll talk about that in the third part, data classification, data management. Now I hope that you feel very certain that your company is at least network operator. And then the first legal obligation is MLPS, multi-level protection scheme. This like MLPS dates back in the 1990s. At that time, there's only like an individual computer, and there's like computer multi-level protection scheme at that time. And then with the development of technology, and this now evolves in the cybersecurity multi-level MLPS. As you can see the chart, see from the slide, there is like different level of law and regulation and national standards, etc., that constitutes the legal framework of this like MLPS. So how this like mechanisms works? It basically is kind of a consequence test again. It's also a consequence test approach. So assuming that the system is attacked by hackers, for example, whether this incident will only like harm the interest of the user, means like the network operator itself. And then if the like the harm is quite ordinary, or is possible, is there will be very serious, grave like consequences, and then that will be determine the network operator at even like level 1 or level 2. Most companies, the MLPS level will be graded as either like level 1 or level 2. If any like network incident will cause like consequence not only to the operator itself, but will also affect the public interest or social order. And the level and the MLPL level will start from grade 2 or even grade 3. And you know, if this like incident will happen, if any incident happens, will affect the so-called national security, and then the MLPS level will be graded at least at minimum the grade 3. So that's the approach of determining the grade. And in practice, usually the process of making the grading is first the network operator will make a so-called determination, and then will invite some technical specialists to review this predetermination process and results. In particular, when this network operator has reasons to believe that its MLPS level is grade 2 or above. And then the network operator will submit this determination results to the authority, Public Security Bureau, and then makes a record filing. That's the approach and process of making the MLPS. As you can see, I just mentioned like this multi-level protection scheme dates back to 1990s, but at that time very limited spectrum. For example, only those like computer information system that relates to national affairs, economic construction, national defense, etc. At that time falls within the MLPS level. Nowadays, we called MLPS 2.0 version covers almost every aspect of information system, cyber network. As you can see, for example, like the cloud computing platform, mobile interconnection, Internet of Things, etc., all falls within the spectrum of MLPS. So in other words, if your entity owns or operates these kind of facilities, your company needs to go through the MLPS. A couple of tips on MLPS compliance. So first, this grading and filing is and this assessment are two separate procedures. It means that once a company make assessment, and the company needs to submit this assessment results and make the filing to the authority in charge. And then this MLPS obligations needs to be performed by each network system. Means that, for example, if your company has SAP, Salesforce, and Workday, HR system, etc., theoretically, this system needs to be assessed separately. In other words, MLPS work needs to be done for each of these network systems. Having said that, in practice, there are ways to convince the authorities to combine several information systems to combine into one. By doing that, the company can save time and cost in making the MLPS assessment. We'll be happy to talk about the details how to combine these systems separately. If you have these kind of needs, please feel free to email us, and then we can talk about offline. And also, if any network operators are graded level 3, and then needs to at least conduct self-evaluation inspection at least annually. For example, if your company owns or process 1 million people's personal data in China, and then most likely the MLPS level will be at least 3. And if that's the case, your company needs to conduct this self-evaluation annually each year. So if it goes to level 4, level 4 is not quite often seen. But if some financial institutes, they constitute level 4, this self-evaluation needs to be done twice every year. And last thing but not the least, nowadays a lot of company take the approach of light assets approach. So they use a lot of like SaaS, PaaS, etc., using the cloud services. They don't have their own like individual separate network. And they may be under illusion that they don't need to go through the MLPS. And unfortunately, even company using this like the third-party network architectures, this company still needs to go through the MLPS. Okay. What if a company fails to fulfill the MLPS obligations? So there will be like penalties for both the network itself and also the person in charge. So there will be like fine for the entity operator range from 10,000 RMB to 100,000 RMB. And for the person, individual in charge of cybersecurity of the operator, the fine will be 5,000 RMB to 50,000 RMB. And we will just list you a couple of like, cases. These cases actually happened in recent, in the last 3 years. And the entity, types of entity ranges from, for example, some technology research institute, some like, some public services entities, and also some commercial entities. So in other words, this like MLPS, like law enforcement now is a like primary task of the authority in charge, and your company may need to be careful if you haven't done this MLPS already. Okay, that's the first part of network operator's obligation. The network operator needs to go through MLPS, multi-level protection scheme. And then the second part, the network operator needs to fulfill its obligation of data classification and data management. When we're talking about data, we need to first find out, differentiate what kind of data we are talking about. We can divide it into two types of data: personal information and non-personal information, because there's a different legal basis to protect personal information and non-personal information. From personal information perspective, the CSL and other related laws and regulations protect the PI, personal information, mainly from the perspective of privacy and also some economic interest. And for this non-personal information, we use a hierarchy. It's like a pyramid. From the top is stay secret. And then the level down is, this one level down is state intelligence. And then the next, important data. And all these like types of data has one feature in common. These data are relating to national security. And then we can also encounter different type of specifically regulated data. For example, human genetic information, human genetic resources data. And these like specifically regulated data are regulated by some specific regulations. And again, although we divide it into two types, and sometimes these two types, can convert to one to the other. For example, some personal information, if they are anonymized, and then may possibly constitute some so-called important data. For example, if any like new drug, and the patients take the new drugs, some adverse effects came to these patients, and although these patients their names, IDs are anonymized, and then still this data can be called important data because it reflects some so-called national health condition. Okay, so I don't want to repeat like one by one because of time limits. And for example, I'll just give you like some essential points. If your company like deals with like state-owned enterprises in China or government departments, make sure when you're receiving the information in data from them, make sure you don't get this like state secrets. Ask them to make it clear in the contracts, in your like collaboration memo, that you will not be receiving the state secrets. And also state intelligence. State intelligence is also is a state secret in short needs to go through very like uh, very specific steps of this level of secrets, like from extremely confidential to ordinary confidential. Let me put this way. But this state intelligence is even harder to define. So make sure when you deal with SOEs or State Departments, make sure you don't receive these two types of information: state secret or state intelligence. And then this important data. Important data, first of all, is not important data which are important in the eyes of the company. It's important data in the eyes of the government departments, the regulators. So in other words, if any information like which are leaked or like misappropriated, that will cause like some social stability, national security issues, etc. And this data will be most likely constitute important data. Again, these are like so-called non-personal information. Let's talk about personal information part. I think some of you may be very familiar with GDPR definition of personal information, which basically is like personal identified information or personal identifiable information. Under the CSL and other related law, personal information is very broadly defined. It basically means that any information that can alone or in combination with other information can either identify a natural person or reflect activities of a natural person. And then that type of information can constitute personal information protectable by the CSL. Let me give you an example. So WeChat is a very popular like social media used in China. So think about it. Like for example, your friend list in WeChat, whether this friend list and your like reread reading history constitutes personal information. Because as you can see that this the law itself gives very like very broad definition. So this PI needs to go through like like court decisions and also the government, the law enforcement decisions, needs to go through this to find like a clearer scope. So in short, in one case last year, this like WeChat friend list and reading list, the court held that these two types of information constitute personal information protectable by the law. And the reason is that friend list combined with other information can identify specifically the WeChat holder, WeChat account. And also the reading history has can indicate the reader's like preference, and also the bookshelves, etc., can reflect the reader's taste, etc. And this actually related reflect activities of natural person. So these two type of information constitute the so-called PI, personal information. Now, I don't want to further confuse our audience, our participants. Just like weeks ago, there's another case in China that the court held that this friend list should not be deemed as privacy. As I mentioned earlier, the law protects personal information for two main reasons: personality, in other words, privacy, and also economic interest. The court said, no, the friend list it will not constitute privacy. So I don't want to like further spend further time on this, but again, this like PI identification, a concept PI will still needs to be examined by the real cases in the future. Okay, so there's a lot of very important concepts. For example, de-identified information, anonymized information, etc. So in short, this CSL takes a similar approach about this, these terms. For example, anonymized data means after this technology processing, this PI cannot be can no longer either individually or combined with any other information can identify any specific data subject, and this anonymized information cannot be restored, and this information will no longer be deemed as personal information. In other words, once the information is anonymized, and then the data controller can freely use this type of can freely use this type of information, anonymized information. De-identified information basically means that after this technology processing, individually it cannot point to any specific person, but with the help of some other type of information, this de-identified information can still point to a specific person, and these are called de-identified information. So and also, sometimes when we deal with our clients in some IT specialists say, no, don't worry, we have taken a lot of hash technology or other encryption technology to make sure this data are anonymized. And then usually we say, hold on, there's some difference between your understanding from technical perspective, technically anonymize the information, and from our legal professionals, because under the law, there's some legal standard for anonymized information. In plain language, there's a specific national standard on this on this criteria of the anonymized information. Okay, so this and we can also further subcategorize PI. There's some personal sensitive information under Chinese law, which means that disclosure or abuse of any such personal information will endanger personal or proprietary safety, etc., and also personal reputation, physical and mental health, or discriminatory treatment, etc., will constitute the so-called sensitive personal information. For example, your wealth information, property information, health information, biometric, privacy, identity, etc., will constitute the sensitive information. So there's also approaches. We're talking about personal information classification, and also for some non-personal information, for example, industrial data, also needs to go through the classification. Also take the so-called consequence test. And if your company has industrial data, it needs to be categorized either class 1, class 2, and class 3. Yeah. And as we mentioned, there's some specifically regulated data, which means that there's special regulation. For example, there's population health data, PHI, we call personal health information, PHI, and also human genetic resource data, etc., and scientific data. All of these data are governed or regulated by individual special regulations. For example, there's a few we just mentioned list a few cases. There's some in pharmaceutical companies, they violate the HGR regulation and transfer HGR information outside of China without appropriate either record or approval, and this company get punished. We just give you an example. This this data, although do not constitute state secrets, state intelligence, or important data, but there are special regulations which govern or regulate this the processing of this type of data. Okay, we have talked about this data classification, and also once the data are classified, and the company needs to work out a whole scheme of data management, and this data management must include the whole life cycle of data. It means that, from data collection to data transmission, storage, usage, sharing, until deletion, the whole life cycle needs to be like processed by the company's data governance policies. A few very special concepts in China. For example, some important data. If any data transmitted by a commercial entity, a company in China, outside China, in other words, important data exports, most likely will go through the so-called security assessment. Um, um, Actually, I'm running out of time, so I need to speed up. I will not elaborate on the detailed steps of this security assessment. So, and also this data export for personal information, and also needs to go through the so-called security assessment. What's the latest trend of personal information protection? Nowadays, a lot of APPs are used, and the China authorities take strengthening the management oversight of these APPs. As you can see from the map, these APPs each year, the authorities examine the APPs online and find out a lot of so-called irregularities and also a lot of violations from the collection, from the use, from the disposal, processing perspectives. And also for personal information export, most likely also needs to go through the so-called data export security assessment. And for example, when this data exporter signs contract with the data recipient, which is located outside China, in the contract, it needs to make sure, for example, how this data recipient, what kind of measures they will take to protect the rights of interest of the personal data subjects, and how the contracts can be effectively implemented, etc. And whether this the exporter has has any history of network security incidents, etc. Yeah, so I would like to wrap up my session to just give you some high-level summary. What your company needs to do to comply with CSL. First, make a self-evaluation to fully understand what is status quo of your company's practice in cybersecurity and data protection. For example, you need to find out what kind of cybersecurity measures and policies and practice are adopted currently in your business organization. And second, you need to identify whether your company is an ordinary network operator, or it's likely that your company will constitute a CIO, or whether or not your company is like ordinary network operator or CIO, whether your company has any important data. And lastly, what kind of personal information your business organization is collecting, using, and processing, and what kind of policies and practice are you relating to the PI practice. And after self-evaluation, due diligence, you will certainly, don't feel surprised, you definitely will see the gaps between the status quo and the CSL requirements. And then we suggest you to run the non-compliance issues from high risk to low risk based on two metrics. First, whether theoretically the legal consequences, whether it's just a fine, penalty is like a fine or monetary fine, or will likely lead to suspension or even cancellation of business license. And second, how frequently the law enforcement happens in this area. And by doing so, you can prioritize all these your compliance measures to be taken. And then the third step, to take the gap mitigation measures to implement these remedial measures, and also to refine and develop internal and external data privacy policies. And in case of need, because in some areas, the law themselves are not crystal clear themselves, and your company may want to consult with regulatory authorities. And last, but very importantly, to train your employees and even make some drills. For example, under CSL, each network operator needs to formulate the crisis management scheme in case of data leakage incident, how your company employees in different roles needs to do in this incidents. So that's what I want to share with you, as the company's obligations and liabilities under the CSL. And I will pass on to my colleagues, Mr. Xun Yang. We are talking about this I'm okay. Thank you, David. Thank you, Jim. Now, I'd like to share with you some main legal issues associated with digital transformation. By way of introduction, I'm a partner here with Links Law China. I have 7 years working experience in IP/IT area, working in Shanghai, Hong Kong, and London. From the IP side, I work on commercial IP matters, including IP strategy, technology transactions, and enforcement. And IT side, I work pretty much on regulatory licensing requirement and cybersecurity requirement associated with building and construction and operation of internet business. Now, I'd like to move one step back to discuss the issues, licensing issues, in a broader picture associated with digital transformation. Now, digital initiatives, digital transformation is a topic I believe most of the companies are thinking about today. Now, and China is in an inevitable market for you. Now, how and what things you think about to establish your online business in China? Now, there are a lot of business models which you can select from. For example, you may simply operate a website outside of China and offering services from that offshore website. And sometimes the local connections in China are not satisfactory, and the connection user experience may be poor. So you would like to establish local relay servers to improve the user experience. And sometimes you do not want to involve in the operation of a website in China. You may deliver your content into your partner in China and for them to post your content in China. And if you want to establish an e-commerce business in China, you may establish an online shop on a local platform such as Alibaba, Tianmao, and Jingdong. And alternatively, if you want to launch a full-scale business in China, you may establish your own local website. Now, there are a lot of factors you need to consider in order to decide your business model. For example, the local connections, with which to have direct intercourse with your customer in China, or probably whether you want to invest into the establishment and local office in China. Depending on the business models, there may be different licenses which you need to have in order to operate your online business in China. Now, the first suit of license is telecom license, because the internet business is considered a part of telecom business. So the first thing you think about is the telecoms related business license. Now, in China, a telecom business can be divided into basic telecom business that refers to the construction and operation of the public networks, now which may be remote to a business. And the second part of the telecom business is value-added telecoms business, which are relevant to a lot of online business. Now, most importantly, within the category of value-added telecoms business, we have B21 license and B25 licenses. B21 license refer to the data processing license, which means you operate a website on which you process a transaction data or other kind of data for third parties. A B25 license is usually called an internet content provision license, by which you can offer content information through your website. Now, for some kind of online business, which I will go into much detail later, it's called a non-operational website. So it does not require permission from the government, but you need to file your website with the government, which we call the ICP filing. Now, there are some other licenses which may be relevant to your business. For example, the Internet Cultural Business Permission, which refer to the offering of cultural products on your website. For example, online game and online music business, which requires a kind of license. And online publication business license, we refer to the offering of the circulation of electronic magazine, electronic publications. And if you want to display some audio and video programs on your website, probably you need to have an internet audio video program permission. Now, so we have all sorts of permission which will be relevant to the operation of website in China. And if your business fall within some specific industrial group, for example, medical business, you maybe need to have some medical device permissions, or if you're offering educational business online, you need to have a scope operation permission. So we have all sorts of permissions which may be relevant to your business. Now, most important, as I said, first things first, when you operate online business in China, you always need to think about whether you need to have a value-added telecoms business license. Now, let's give you some explanation about the two very important type of value-added telecoms license, B21 and B25. As said, B21 license refers to the license by which you can process data online for third parties, and it most commonly used in the operation of an e-commerce platform. Now, why an e-commerce platform requires a B21 license? That's because when you operate an e-commerce platform, you always need to process the transactional data between the buyers and sellers. So you have the buyer's data and seller's data and match them and to create a transaction. That is naturally a process of data. So generally speaking, the operation of an e-commerce platform requires a B21 license. And B25 license refers to the internet content provision license. And basically, if you're offering some information from your website for a fee, for a profit, you will need to have the B25 license. And the most common example is online advertisement. So when you display advertisement on your website for a fee, then you need to have B25 license. Now, it is quite difficult for foreign companies, foreign invested companies, to apply for B21 or B25 license, although it's not impossible. The standard is quite high. But fortunately, for most of the foreign investor business, you do not need to have the B21 or B25 license, but you need to have an ICP filing. Now, what is an ICP filing? ICP filing refers to the file of a website with the government, and on the condition that the website is not for profit. Now, the government defined the concept not for profit broadly. Basically, if your website, the website operator does not generate profit directly from the provision of information from the website, it is a non-operational website, and you only need to have an ICP filing. So if the website is a company website, it's general introduction to your company, then you only need to have an ICP filing.
However, sometimes we can see that although the website is launched for business, but still require only an ICP filing. Why? Let me give you an example. Now, if you are selling products on your website, then in that situation, we are not provision of information for a fee on the website. We are selling products. So the profit we generate from operating the website is from the sales of the products, not the operation of the website. So in that situation, we only need to have an ICP filing, not a license. Now let's take a digital healthcare business example. If we sell some medicines or some medical device on the company's own website, then we only need to have an ICP filing, not a license, because we generate profit from sales of products, not the operation of the website. However, if we operate a platform to facilitate a lot of pharmaceutical companies to sell products on the website, from which we generate brokerage fees, then in this situation, the business is considered an operation of an e-commerce platform, and which is the value-added telecom business, and it requires a B21 license. And if, for example, another example, if we have a hospital, and the hospital can go online as well. It launched a website to establish an online appointment-making facilities. Then the website is considered non-operational, because the hospital naturally is to build the best business of offering medical services offline, and the website is only facilitate the transaction happens. So the website itself is considered non-operational, although the hospital can collect some consultation fees online. However, if it's a general internet website which allow third-party hospitals to have a portal on its platform to make appointment and to collect medical service fees, and from which the platform generates some service fees, then the platform will be considered value-added telecoms business and requires a license. So as a result, there is some subtle difference between ICP filing and operation of a for-profit of website. Now, as said, especially when we are offering information from website or we operate kind of platform, we need either B21 or B25 licenses. Is there any way for us to bypass the license requirement? Now, historically, VIE structure is a way to bypass these kind of license requirement. However, it's not very popular these days. There are a number of reasons. Now, for those who are not familiar with VIE structure, in a very simple way is for the foreign companies which establish kind of technology company in China, wholly owned, and to have some Chinese employees to establish Chinese company with a proper license, and then have the license technology company to have operational control over the license code. Now, VIE structure was very popular, but not very popular now. Now, because the VIE structure was designed to facilitate, initially to facilitate Chinese managed internet portal companies to go IPO overseas. Now, they're not designed for foreign companies to enter into China by bypassing the licensing requirements, especially in some sensitive area. For example, the online cultural area, the online transmission of movie products, and online, especially the operation of online schools. The government will look into the management control in addition to the capital control. So VIE structure does not work in these areas. But we have some other ways to bypass the license requirement. And one of the important way is the so-called licensing model. For example, if the key assets of the foreign party is the technology, it can potentially license the technology to its Chinese partner for the Chinese partner to operate kind of proper licensed business in China. The typical example is Microsoft. In China, the internet data center business is a licensed business and is generally not open to foreign investment. So Microsoft is very clever. It found a partner, a small company in China called 21Vianet. Microsoft licensed its technology related to cloud business to the Chinese partner and allowed Chinese partner to operate the IDC business in China by using Microsoft technology. By doing this, the responsibility of operating the IDC business sits with the Chinese partner, but Microsoft gets the substantive portion of revenue. And also through a license arrangement, Microsoft is able to exercising a certain level of control over the operation of the business. And another example relating to educational business. Now, a lot of publication shops in the Western society, they wish to enter into the China market, especially in the educational kind of content market. However, the Western publication shops, they are not able to publish educational materials in China because this is a very sensitive area. However, they can license the Chinese publishing house to grant the Chinese publishing house a license of the content which they wish to publish, and instruct the Chinese partner to publish the materials. So in doing this, the foreign publishing house can potentially working around the licensing requirement. Now, in addition to the licensing requirement, there are a lot of other regulatory requirements in relation to the operation of online business in China. Now, number one, in relation to the operating website, we have cybersecurity requirement and a data protection requirement. This is an area which is inevitable. Now, I believe David has gone through some of the issues, and my colleague Nigel will go into much detail later. So I won't talk much about cybersecurity. And also, if you are operating an online shop, you'll be responsible for the content displayed on the shop, especially whether there are any infringing issues, whether in the content or brand may potentially infringe the IP rights in China. And if you are operating a platform, allow third parties to place their listings on your platform, you need to manage these the online users to be responsible for their true identity, their legitimate operations, and non-infringement. Now, that naturally leads us to the next topic about the intellectual property issues, the brand protections and IP protections. Now, when you initiate your digital initiatives in China, potentially to operate online business in China, intellectual property issues is always one of the top things you need to consider. Now, the China IP law regions are not very different from the Western society, especially we are quite similar to the German law system in terms of IP laws. For the online business, of course, the copyright is a very important part. The software behind the online business is protected by copyright, and the text, the pictures, the music, and even the font, the way of the characters, the letters are protected. And also the initial business, if there's an initiative business process, then the business process can also be patented. Now, the scope of protection of business models in China is somehow broader than those in the European law, but probably narrower than the US law. We are in the middle. Now, particularly important for the operation of an online business requires a good brand protection strategy. And also the data protection is an important issue too. So let's have a look at the brand protection strategy. Now, when you have a business, you wish to expand your business into China. Now, the brand issue is an important issue because everything is intangible. Now, consumers will recognize the goodwill only according to the brand. Now, what are the elements you need to consider when you enter into the China market? What constitutes a brand? Of course, number one, trademark. And number two, domain name. And number three, company name, if you have a company in China. In an ideal situation, you would like to need to have your domain name and the company name to be consistent. For example, the company is ABC LLC in UK. You would like to register the ABC mark in China, and you have your abc.com.cn domain name. At the same time, your company name probably ABC blah blah.com, the company limited in China. So the trademark is regulated, is admitted by the China Trademark Office, and the company name is regulated by the local administration for commerce, industrial commerce. And domain name, of course, is issued by the domain name register. So most likely, you need to have availability search in 3 areas, and to make sure that you have a consistent the trademark domain name and company name. Now, very important, different from the UK law. In China, we have only very limited protection on unregistered trademark. So first thing first, when you enter into a business in China, you need to make sure that you register your trademark in China. Now, and also I'd like to draw attention to the concept of Chinese mark. A lot of Western companies, they directly introduce the Western mark into China, as ABC, as the Western mark. Now, if you enter into Chinese market, I will recommend that you select a Chinese version of your mark to be registered in China. Now, why? If you do not register a Chinese mark, it's likely that Chinese customers, Chinese consumers will create a Chinese version, Chinese translation of your mark, over which you will lose control. Let me give you an example. Pfizer has a famous medicine product, Viagra. Now, Viagra is kind of very innovative and a very successful product. Now, before Viagra was introduced into China, the media has already created a name for Viagra, Great Man. Great Man. Sounds like Viagra, and the meaning is Great Man. It's such a clever creation. However, Pfizer did not realize that the existing of Chinese name and allow, basically, as a third party, register the name Great Man in China, of which Pfizer does not have any control, because the name is not created by Pfizer, and Pfizer has never used the name before. Now, so when you enter China, please consider and create a Chinese name for yourself and have the name registered with the China government. Now, also, there are a lot of regulatory considerations for brand strategy. Now, when you establish a website, you need to have the ICP filing and the name of the same person of the domain name owner, and that owner must be the actual operator of the website. If you are operating a for-profit website, which requires a value-added telecom business license, then you need to ensure that the trademark owner, the domain name owner, and the license owner be the same person. So you cannot have your parent company overseas to own the trademark or the domain name and have the local company to operate, to have the license to operate the platform. You can't do that. You must transfer the trademark and domain name into the possession of the Chinese company. And also, the Chinese advertisement law has some restrictions on selection of the brand. For example, the superlatives are not allowed to be used in China as a brand. Now, as that in UK, we have the famous supermarket Tesco, and Tesco has a brand Finest. Okay, if we're to a high-end product. Now, the word Finest can be registered as a trademark in UK, but it cannot be registered as a trademark in China because it's a superlative. Now, if you are offering you are operating an online shop on third-party platforms such as Tmall and Taobao. Now, there may be some rules enacted by these platforms. For example, if you want to establish a flag shop on Tmall, then the operator of the flag shop must be either the trademark owner or the exclusive licensee. So you cannot grant a license to a third party and ask them to operate a flagship shop. Now, after we talk about the brand, another very important element is the data. Is data protectable in China? Now, this is a very difficult question because the data have lots of varieties. In China, basically, the using of cloud techniques, the collection of data by using cloud technologies is, by its nature, is not illegal. So we can use it, but we cannot use the cloud technology to overrun, to bypass the controls to intruding into third-party computer systems, and it is not allowed to collect data from third parties for the purpose of competing with the third parties. So in other words, data themselves are not intellectual properties per se. However, they may be protected under the unfair competition laws. So it will be considered a kind of intangible assets which are protectable, but it's not IP rights. For example, we can collect data from some other third-party websites for the purpose of our own analysis, but we cannot collect that data to engage into same business or competing business with the company from which we collect the data. Now, in the last session, originally I planned to have a discussion on the legal issues arising from innovative technologies, including electronic signatures, AI technology, etc. Due to the time limitations, I won't go into much details one by one. I'd like to illustrate that for almost the application of all innovative technologies in relation to online business, there are two common legal issues we need to consider. One is IP protection, because it's innovation. You always need to consider whether we can have to use some IP tools to protect our creations, and also the data issues. Whether the operation of the innovative technology will need to collect third-party, either personal data or non-personal sensitive data, which will the operation of the technology potentially permitize to third-party rights. So the data issues, cybersecurity issues are always inevitable. And in addition to these IP issues and cybersecurity issues, there may be, and in a lot of circumstances, there will be regulatory issues. For example, if we are using AI technology to perform robot advisor business to advise on investment in secondary markets, in such situation, the CSRC, the securities regulator, will consider whether technology itself will exaggerate the market risks. So there will be some the regulatory issues will be relevant, especially from a public security and public interest point of view. And of course, if you are operating a digital healthcare business, So in addition to the IP issues, the separate issues, we need to consider whether the use of the technology will affect the patient's rights, whether we will cause any potential harm to the patients. So always we need to consider the regulatory issues from the relevant regulators. Now, due to time restraint, here as my sharing, I will pass the speaker to Nigel.
Thank you, Mr. Yang, and good afternoon, everyone. My name is Nigel Zhu, and I'm a senior associate at Lynx Law Offices. I have over 7 years of experience practicing law, mainly cybersecurity law and antitrust laws, and my practices focus on cybersecurity and data compliance recently. I realize that I have limited time, so I will probably skip some of the slides, but I'll keep the main points. Today, I will be talking about compliance of cybersecurity products in China. When we talk about cybersecurity products, most people would probably think of antivirus or anti-spam products, but actually the scope of cybersecurity products is far beyond that. And Chinese law, it actually regulates all of the manufacturers, sellers, distributors, and even users of cybersecurity products. And that means the compliance of cybersecurity products can be relevant to everyone here in the audience today. And my presentation will be in 3 chapters. In the first chapter, I will briefly introduce the legal framework of cybersecurity law and cybersecurity products in China. And in the second chapter, it's about certification and licenses for cybersecurity products. And in the last chapter, I will share some of the concerns and issues applying for certification and licenses and also using cybersecurity products. Okay, let's first begin with the legal framework. As Mr. Pan David just discussed, cybersecurity law, China's cybersecurity law is actually a very broad topic, but basically it can be divided into 2 main aspects, cyberspace security and cyber content security. Cyberspace security is about the IT environment. It's about hardware. For example, your IT infrastructure, your network systems and your network devices and your software. And cyber content security, it's about what flows in those IT environments, meaning data or any other information like personal information, important data, and any other regulated data. Actually, the relationship between these 2 is very straightforward. You can just think of cyberspace as a highway, and cyber content, the data, is all the vehicles on this highway. And here the question is, where do cybersecurity products fit in this picture? The law actually does not give a very clear answer, but I would probably say that it fits into both cyberspace security and cyber content security, because you can simply imagine antivirus software products. They first of all protect your hardware, meaning your laptop, your computer, your PC, and also your IT environment. And they also protect your cyber contents, meaning your Word, Excel, PowerPoint documents stored in the IT environment. That tells us that cybersecurity products can be subject to PRC laws on both cyberspace security, and also cyber content security. And now a bit more about the legal framework of cybersecurity products. PRC law mainly regulates cybersecurity products through certification and licensing requirements. So here you can say, in addition to the general cybersecurity obligations, there's mandatory cybersecurity certification, which I'll be talking about in chapter 2. And there's also voluntary cybersecurity certifications. And also there's data export and cybersecurity requirements, which are not licensing requirements per se, but they are related in this topic. Okay, in this chapter 2, I'll be talking about mandatory certification and licenses. The first license that I'll be talking about is called Computer Information System Security Special Product Sales License. It's a very long name, so I just call it sales license. The cybersecurity products caught by this license is hardware and software intended for protecting the security of computer information system, which is a very broad and abstract concept. But from a practical perspective and from the perspective of manufacturers or sellers of this special security special products, the most important and probably difficult task is to figure out whether their products fall into the scope of the sales license. And we can take a look at this abbreviated catalog published by the Ministry of Public Security of the PRC, and we can refer to this chart to figure out whether our products fall into the scope of the sales license. And you can see in this chart, it's divided into 3 columns, and on the left side, it's the 5 main categories of the sales license, and each category is further divided into sub-levels. For limited space, I only list one level 1 and one level 3 category of product here, but you can see there are already many multinational companies that have obtained their licenses for their cybersecurity products in China. For example, in network access control, we have Cisco. In anti-malware, we have McAfee, and also Windows, Microsoft Defender. And in data protection, we have Symantec. And in security management, we have some Chinese companies, Tencent and Huawei. And this, the full version of this catalog can be found on the website of the Ministry of Public Security. So I strongly advise every product producer of cybersecurity products intending to market their products to Chinese users to study the chart carefully. From another perspective, from the user's perspective, you may think that the sales license is irrelevant to you, but this is actually not true. Because depending on the business and your services offered, even users can be required by law to purchase or use cybersecurity products with a sales license. And here, VPN can be a very good example. VPN was originally designed for encrypted communication. It was not originally designed for climbing over the Great Firewall. So therefore, VPN falls into the sales license. It's a cybersecurity product. And if your company purchases and deploys VPN services for intra-group communication in China, you will need to check whether the VPN product you purchased has a sales license. And if not, the product may be banned or outlawed, and you may suffer interruption to your businesses. And the second certification category we'll be talking about is critical network equipment and specialized cybersecurity product certification. The purpose here is to identify cybersecurity products that may be used by systematically important entities. For example, the CIO that David just talked about, and require such products to be certified before they can be sold and used by these CIOs. And here also we have a chart which is drawn based on a catalog published by the government authority in charge, which is CAC. You can see on the left we have 4 categories of critical networking equipment: routers, switches, servers, and PLCs. And on the right we have 11 categories of specialized cybersecurity products. Please note that not all the equipment or products here are critical or specialized products, because there are thresholds, there are specification thresholds. For example, servers, not all servers are critical network equipment. Only servers meeting the following specifications constitute critical network equipment. They must have at least 6 CPUs, and each CPU with at least 14 cores. And the servers must have at least 256 gigabits of RAM. Only these kinds of servers fall into this category. So in evaluating whether your products fall into this catalog, you must bear in mind the specification thresholds. Otherwise, you may incorrectly categorize your products into this catalog and increase your cybersecurity compliance burden. Okay, next we talk about telecommunication service licenses. Mr. Yang already discussed in detail about this license. The reason this license is in my presentation is that telecommunication services, they can constitute cybersecurity products as well. For example, cybersecurity products that create closed-end user groups and utilize tunneling technology. Such telecommunication services, they may be deemed a VPN service and need to acquire a telecommunication license for VPN in China. In addition, certain cybersecurity products, they are with a PaaS or IaaS structure. And such cybersecurity products, they may constitute Internet Information Services, which is a kind of telecommunication service. And if so, an ICP license must be obtained before they can be sold. And engaging in telecommunication services without a proper license can bear severe legal punishments. And the dilemma here is, you may unknowingly violate the law because you didn't realize that your cybersecurity products constitute telecommunication services and need a license. So we encourage cybersecurity producers and also users to explore the possibility that their products need a telecommunication service license to avoid any legal liabilities or interruption to their business continuity. Next, it's about commercial cryptographic certification, product certification. Not long ago, cryptographic products, even commercial ones, they are heavily regulated. And you have to have a certificate for almost everything you do about a cryptographic product, like importation, selling, using the product in China. For almost every step, you need a certification. But that has mostly been changed by the newly effective cryptographic law, which provides that unless your cryptographic product fall into the catalog of network critical network equipment, which we just talked about, unless your product fall into that catalog, commercial cryptographic products no longer need to be certified before they can be manufactured, imported, sold, and used. But that doesn't mean certification of your cryptographic product is meaningless. The potential commercial value may come from higher purchase preference of buyers and also eligibility for government and state-owned companies' procurement. For example, a recent tender published by the National Immigration Administration of China for its procurement of cryptographic product requires that the bidder's product to be certified by a competent certification agency. Also, from a user standpoint, other things equal, you should always consider cryptographic products that are certified. That is our advice here. And next, I will be going to talk about data export and cybersecurity review, but I'll probably just very briefly discuss them. Data export and cybersecurity review, they are not certification or licensing requirements per se, but they affect the behavior of the users of cybersecurity products, and therefore can in turn affect the producers and manufacturers of cybersecurity products. For example, in relation to data export, if your cybersecurity products were sold to CIOs in China, for example, large petrochemical companies or energy companies in China, and the way your cybersecurity products function involves transferring personal information or important data, even in encrypted form, from your Chinese client to servers outside of China, for example, in the US or in the EU. That may trigger data export security assessment obligations on the side of your client, meaning the CIOs, and you as the service provider of the cybersecurity products will have to work with, assist your client, and sometimes accept unfavorable terms in order to help them complete data export or cybersecurity review procedures, and that may be done to the detriment of your company's interest. So, in marketing your cybersecurity products to especially CIOs in China, you need to evaluate the possibility of their obligations in relation to either data export or cybersecurity, and see if you can accept the terms that are not so favorable to you, and also have a detailed plan dividing rights and obligations between you and your CIO client in the procedure of data export assessment or cybersecurity review. Okay, in the last chapter, I will briefly talk about some of the concerns and issues in relation to cybersecurity products. First of all, and I think the biggest headache here in complying with Chinese laws on cybersecurity products is determining the appropriate certification and license requirements, because that is not crystal clear all the way. So the first thing you need to do here is, of course, to understand your own product. You need to understand the design, the functionality, even the source code used or an algorithm used to produce your cybersecurity products. And these are the facts in determining proper certification and licensing. Second of all, remember that determining the certification and licenses is a very comprehensive assessment. You need to consider every possibility to exhaust the options here and requirements here on cybersecurity certification and licenses. The mandatory certification I mentioned in chapter 2 is only a small portion of the mandatory certification and license requirements under PRC law. And also remember there are voluntary certification and licensing requirements. So you don't want to miss one or more certification licenses, so that you later get punished by the Chinese government for not complying with Chinese law. And because this is such a difficult task, we always encourage our clients to, before marketing their cybersecurity products in China, to consult with relevant government authorities in charge on the necessary certification and licenses they need for their products. And even that is not 100% safe, because first of all, the government's preliminary opinion on certification license may not be, it does not have any legal effect. It's not binding, so it can be wrong. Also, you may not be able to determine all the necessary government authorities in charge. So to solve this issue, we always encourage our clients to engage a local legal counsel that is experienced in this area to help them navigate the sometimes murky laws in cybersecurity certification licenses. And last, remember that getting the product certified is not the end of the story. It's actually an ongoing process, and because you certify the samples of your products, and if later the product in the market they differ from the samples tested, or if your products undergo certain changes after they are in the market, you will have to, the certification may have to be amended or revoked, and you may have to reapply for applicable certification licenses. And the second common concern is disclosure of information confidentiality. Some foreign clients, they worry that if they disclose information in the process of applying for the certification licenses for their products, they may give away their trade secrets, their proprietary information, or other sensitive information, and that information may be misused to their detriment. But based on our experience, the reality here is that in most certification procedures, the testing only involving testing the functionalities of your cybersecurity product. In other words, the agencies, they are testing a product from the perspective of the user. Normally, it will not involve dismantling of the products, or reverse engineering, or they won't even know, they won't even touch the source code of the products. But in certain certification process, for example, certification for cryptographic product, the level of information disclosure may be higher, because they need you to give them the encryption algorithm and other possibly sensitive information for them to complete the certification process. And that's where you need to be cautious in giving away information. There's always room to argue with the certification agency, and as long as you can prove that the information you give is sufficient for the certification, you can stop them from asking for additional information that you don't feel comfortable with. But the bottom line here is any information disclosed to testing or certification agency or government authorities is required by law to be kept in strict confidentiality, and they are not allowed to share the information to anyone else. Last, I'm just going to skip this slides because it's. I'll talk about the time frame for you to get your product certified, and it can vary, because as you can see here, some take only as few as 15 business days, and some can go up to 180 days. So the advice here is to always plan ahead and leave enough buffer time in your in your plan to market your products in China, because before you can legally offer them to the market here in China, you may have to wait for a very long time for your product to get certified or licensed. So here is just time frame of certification process for a reference. And my last advice today is that always remember that cybersecurity certification or obligations, they are not only the suppliers, meaning the manufacturers or producers of cybersecurity products. They're not only their concern. These can concern users, buyers of the products as well. I understand that most of the people in the audience, their companies, they're buyers, they're users of cybersecurity as opposed to producers. But these should be, you should be watching out for potential risks and legal issues in relation to cybersecurity product. For example, we just talked about data export and cybersecurity review. For example, if you are a CIO and you are purchasing cybersecurity products, you need to be able to figure out whether the products involve any exporting any data of yours outside of China, or if your purchase of the cybersecurity product itself will potentially pose any threat to the national security and therefore trigger your obligation to go through the cybersecurity review process. So the mentality here is, the key point here is that you should keep a mentality and you should be aware of both suppliers and the buyers' obligations in relation to cybersecurity products, so that you can stay fully compliant with PRCO. And that's all for my presentation today. Thank you all for your time. Back to you, Jamie.
Thank you very much, Nigel. Thank you to Shun and David as well for your really comprehensive and distinct 3 parts of presentation there. I am conscious of time, and I am aware that we have received really a fantastic amount of questions through, more than actually any webinar that I've ever had before. So I might have to be selective here. But I see no reason to wait. We'll get straight into the questions. The first one has come through here and asks, we are developing a technical solution for market analysis. Is there a requirement that we disclose the solution to our business partner in China?
Okay, the answer will be, it depends. From an IP point of view, there's no requirement that anyone need to release the formula or any kind of confidential information to China. But however, if you the AI, the solution is used for analysis the security market and used for global advanced business, there will be a requirement that you disclose the formula with the government to avoid any significant risk to the security market. So it needs to be assessed by a case-by-case basis. But generally speaking, the IP is protected, but there may be some regulatory requirements.
Okay, we are a hotel franchise in China, and we offer public Wi-Fi services to our customers. What are our obligations in relation to cybersecurity products?
I think probably Nigel can help answer this question.
Okay. As I mentioned, cybersecurity products, they not only, the legal obligations not only concern suppliers, but also users. In this case, your company is a user of can be a user of cybersecurity products, because in certain local areas here in China, the government may require public Wi-Fi service providers to install cybersecurity products with a sales license to protect their IT environment and to provide the Wi-Fi services they offer to their customers. So yes, that can be a legal obligation, and you need to check with the local government to see if that rule is enforced in your area.
Okay, I should have mentioned those two questions actually came through anonymously. We have another here from Stephen Castell, who asks, are citizens' facial recognition data defined as personal or non-personal data? If non-personal, which classification, for example, state intelligence, would they come under?
Sorry, Jeremy, can you repeat the question? Which method can be? So Jeremy, can you repeat the question? You kind of, yeah.
Yeah, no problem. Is citizens' facial recognition data data defined as personal or non-personal? If non-personal, which classification would it come under? E.g., state intelligence.
That's a very interesting question. For example, if this facial recognition is used in some like public places, like in metro station or like some transportation hub, even you using some technology to anonymize, to like remove all the features, the numbers of the passengers passing at a specific time point at very specific place may be relevant to the so-called social security. It may not be that sensitive enough to constitute state intelligence, but it will be likely to constitute the so-called important data, as I mentioned in my presentation. So if that's the case, it will be subject to the regulation of the so-called important data.
In your experience, how well prepared are Chinese companies for large-scale cybersecurity attacks?
Cybersecurity.
Or cyber attacks, yeah. To be very honest, in some so-called in some specific industry, for example, financial and also some telecommunications and large-scale platforms, they are very prepared for the so-called cyber attacks. But for some other like industries, including those which are very, very vulnerable, for example, healthcare industries, to be very honest, they're not very prepared. They're not ready for this like cyber attacks. And each year there's still quite a lot so-called cyber attacks on these like network operators, and there are some so-called penalty issued to these network operators. In these cases, they are, although they are victims, they are so-called victims of this like cyber attacks, but because they either like don't fulfill the obligation MLPS, so they still get punished. Yeah.
Okay, I think we have time for maybe just one or two more questions. This one should be relatively should generate a relatively short response. When a data breach becomes public, what is the best way to respond?
I try to keep my answer short. We have helped some clients in handle this like data breach. First, you need to determine the scope of data leakage. How many so-called data subjects information, and second, what type of information leaked, and third, make a reporting, because make a reporting is not your choice, is like mandatory obligations. But before reporting, as I mentioned, the company needs to do some homework. As I mentioned, like the types and the volume of data leakage and the possible consequences of the leakage.
Yeah, at that point, probably you need to look at your insurance policies when it's covered. And sometimes there are requirements for reporting to the insurer before you make substantial actions.
That's a very good point.
Okay, one final question. If the sender sends important data abroad without proper approval, would the data receiver incur any liability, or is the liability with the sender?
In terms of important data, this data recipient still needs to take some measures to so-called safely store and safely use and safely process the data, because the important data, the logic to protect the important data is from the so-called national stability and national security perspective. So A short answer, data recipient still needs to take some measures, data security measures. Yeah.
Okay, I do believe that's all we have time for. Thank you very much to David. Thank you to Nigel, and thank you to Shun as well. So yes, thank you all for sharing your thoughts and your insights, as well as to our audience for your time and participation in the form of all those questions. I'm sorry we couldn't get to all of them, but I hope what we did get to gives a good kind of spread into the topic.
Yeah.
I hope this has been an insightful session for all of you, and that we've all taken something from today's discussion. Just to close, the Legal 500 would once again like to thank Links Law Offices, our partners for today's webinar. If you have any feedback for us about today's event, perhaps what you'd like to see from us, or just more general feedback, please do let me know. You can contact me via email, jamie.ray@legal500.com. All there is to say is thank you all for watching, and that concludes today's webinar.
Yeah, thank you, Jamie. Thank you all. Yeah. Thank you. Bye-bye.
Thank you.